I want you to just close your eyes for a second. Picture this. You run a construction company.
Okay.
Not a massive conglomerate, just a, solid family-owned business. You've spent the last 6 months of your life working on a bid for a government road project.
Months. Yeah, I can feel that.
You've hired surveyors. You've crunched the numbers until your eyes bled. You've barely slept. You submit the binder. It's perfect.
Yeah.
Objectively, you are the best option.
You can practically taste the contract. It's the break you've been waiting for.
Exactly. And then a month later, you check the website. The contract was awarded.
But
not to you. It went to a company that, well, let's just say, didn't even have a valid trading license when the bids opened.
Oh, no.
A company that, by the government's own rule book, shouldn't have even been in the room.
That is the moment your blood runs cold. It's not just disappointment, it's rage. It's a visceral sense of injustice.
It's that specific feeling of, wait, the game was rigged.
Yeah.
But here is the terrifying question. When a powerful government minister or a university vice chancellor or a licensing board makes a decision that is flat out wrong, who tells them to stop?
Who checks them?
Who checks them?
That is the fundamental question of administrative law. Who referees the referees?
Precisely. Today, we aren't just talking about abstract legal theory. We're talking about the only thing standing between you and the crushing weight of the state. We are doing a deep dive into the machinery of accountability. We are talking about judicial review.
It sounds dry, doesn't it? Judicial review, like something you'd skip over in a contract?
Right.
But in reality, it is the high court's, what they call its supervisory jurisdiction. It is the superpower that allows a judge to look at a minister and say, you crossed the line, go back.
So our mission today is to open up the hood of this machinery. We want to understand how the courts keep public authorities, from school boards to the police, in their lane. We have a massive stack of sources today. We're looking at comprehensive legal texts on administrative law, focusing specifically on the Ugandan and English context, plus a mountain of case law.
Oh, yeah. We've got stories about airport advertising, tenders gone wrong in Entebbe, rebellious cotton farmers, police chiefs fired in the middle of the night.
And even spies at GCHQ.
And spies. Don't forget the spies.
It's going to be a ride. But before we get into the weeds, I need to stop you, because when I hear judicial review, my brain just thinks appeal. If I lose a case, I appeal. Why is this different? Why do we need a special term for it?
I am so glad you asked that immediately, because this is the single biggest stumbling block for everyone, including, first-year law students. You have to completely rewire how you think about a court case.
Okay, rewire me.
Think about a standard appeal. If you are sued for a debt and you lose, you appeal to a higher court. In an appeal, you are effectively asking the higher court to step into the shoes of the lower judge.
Right.
You're saying the judge got the facts wrong, or the judge believed the wrong witness. You are asking for a merit-based review.
Right. You want a do-over. You want the new judge to look at the score and say, actually, you win. The first judge was an idiot.
Harsh, but yes. You want them to substitute their decision for the original one. But in judicial review, the high court cannot do that. They absolutely cannot look at the merits of the decision.
Wait, pause. They don't care if the decision was good or bad.
Not in the way you're thinking. They don't care if the decision was smart or efficient or even particularly fair in a moral sense. They only care about one thing. Was the process of making the decision lawful?
That sounds incredibly frustrating. If the decision is wrong, why can't they just fix it?
Because of the separation of powers. I mean, ideally, we elect politicians and appoint administrators to make policy decisions. We trust them to decide where to build roads or how to run schools. We don't elect judges to run the country. If judges started overturning decisions just because they disagreed with them, just because they thought, well, I wouldn't have done it that way, they would effectively become the government.
Ah, I see. So the judge isn't the coach trying to win the game. The judge is.
The referee. This is the best analogy to keep in your head for the next hour. Think of the high court judge in a judicial review case as a football referee.
Okay, I'm picturing it. Whistle, cards, the whole deal.
The referee doesn't care which team wins. The referee doesn't decide if the striker's strategy of playing defensively is a good strategy or a bad strategy.
Right.
You can play a terrible game, make awful tactical choices, and lose 5-0. The referee won't blow the whistle for that.
Because playing badly isn't against the rules.
Exactly. But the second you pick up the ball with your hands, the second you break the process of the game, the referee steps in.
The whistle blows.
The whistle blows. Judicial review is the referee blowing the whistle on a foul.
So, to bring it back to the government, The minister can make a decision that I think is stupid. They can decide to build a bridge to nowhere. And the court will say, that's a stupid bridge, but you have the power to build it, so go ahead.
Correct. But if the minister decides to build that bridge by seizing your land without a hearing or by awarding the contract to his brother without a tender process,
Queet.
whistle blows. That's a foul.
That makes it click. It's about the rules of engagement.
There is a famous quote from Lord Hailsham in this case, Chief Constable of North Wales Police v. Evans. He put it brilliantly. He said, "The purpose of judicial review is to ensure the individual receives fair treatment, not to ensure that the authority reaches a conclusion that is correct in the eyes of the court."
So it's about protecting the player from being tackled unfairly, not about deciding the final score.
Precisely. Because if the courts started deciding the score, we'd be living in a juristocracy ruled by judges. And nobody wants that.
Okay, so we know what the referee does. Now let's talk about the rulebook. If I'm that construction company owner, and I'm furious, on what grounds can I actually get the referee to blow the whistle?
To understand that, we have to look at what we call the CCSU framework. This comes from a landmark case, Council of Civil Service Unions v. Minister for the Civil Service.
The CCSU case.
Most lawyers just call it the GCHQ case.
GCHQ. That's the British spy agency, right?
It is. We'll get into the spy drama of that case a bit later because it has a sting in the tail.
Okay.
But in that judgment, Lord Dipluck, one of the great legal minds, laid out the roadmap. He said, effectively, if you want to challenge a public body, you generally have to argue one of three things.
The three pillars.
Exactly. The three grounds are illegality, irrationality, and procedural impropriety.
Illegality, irrationality, procedural impropriety.
Yeah.
It sounds like a diagnosis for a very chaotic person.
It does a bit, doesn't it?
Yeah.
But think of them as the three main chapters of the rulebook. Illegality is you did something the law doesn't let you do. Irrationality is you did something so crazy no sensible person would do it. And procedural impropriety is you did it in an unfair way.
Okay, let's unpack these one by one. Let's start with ground one. Illegality. Or, if we want to sound like we paid for law school, substantive ultra-virus.
Ultra-virus, it's Latin for beyond the powers.
I always imagine a superhero movie when I hear that. He is gone. Ultra-virus.
It's less superhero, more bureaucratic cage. The core idea is the four corners doctrine. Imagine a statute, a law passed by Parliament, is a box. It draws four corners.
Right.
A public authority, whether it's the Coffee Development Authority or the Minister of Health, only exists inside that box.
They aren't like you or me.
Exactly. You and I, as private citizens, we can do anything we want as long as it isn't illegal. I can wear a green hat, I can eat ice cream for breakfast. I don't need a law to tell me I can do that.
But the government is different.
Completely different. The government can only do what the law explicitly empowers it to do. If the law says the transport authority can regulate taxis and they try to regulate, I don't know, stores.
Yeah, they're out of bounds.
They are outside the box. They are acting ultra-virus. They are acting illegally.
I want to look at a specific case from our sources because it really paints a picture of this box. And it's that construction nightmare I hinted at earlier. Clear Channel Independent? LTDV Peak CA. This happened right here in Uganda.
This is a textbook example of illegality, and the facts are just wild. So you have Clear Channel, a big advertising company. They wanted the contract to manage advertising billboards at Entebbe Airport.
Prime real estate. You land, you see the ads, it's worth a lot of money.
Huge money. So the Civil Aviation Authority, the CAA, puts out a tender. Clear Channel submits a bid, but the CAA rejects them and awards the contract to a competitor.
Clear Channel smells a rat.
They do. They realize the process looked funny, so they run to the referee. In Uganda, regarding government contracts, the referee is the PPDA, the Public Procurement and Disposal of Public Assets Authority.
Their whole job is to make sure tenders are clean.
That's their entire reason for being. So Clear Channel files a complaint. Hey, check the tapes.
Right.
Exactly. The PPDA investigates. And guess what they find?
They find the foul.
They find a massive foul. They agreed that the evaluation process was flawed. They agreed that there were significant irregularities. They basically said, yes, Clear Channel, you are right. The CAA broke the rules.
Okay, so slam dunk. Clear Channel wins. The contract is canceled. We start over.
You would think so. But here's the twist that makes your head spin. The PPDA, after finding that the process was illegal, said, however, we're going to let the procurement continue anyway.
Wait, what? They found it was broken and said carry on.
Yes. They effectively said, it was illegal, but we're too far down the road now, so let's just let it slide.
That sounds insane. That's like a police officer watching someone rob a bank and saying, well, they've already got the money in the bag, let them go.
Exactly. And that is why Clear Channel went to the High Court for judicial review. They challenged the PPDA's decision to let it slide.
And what did the court say?
The court slammed the gavel down hard. They held that the PPDA's decision was ultra-virus. The court said, essentially, you are a creature of the statute. The law says if you find an illegality, you must stop it. You do not have the power to sanction an illegality.
You can't bless a sin.
Correct. By saying it's okay, the PPDA stepped outside its box. They tried to exercise the discretion they didn't have. The law does not give them the power to ignore the law.
That is a really strong precedent. It tells every regulator, if you see a wolf, you have to bark. You can't just say, well, it's a nice wolf, let it in.
Precisely. And illegality takes other forms too. It's not just about ignoring the rules. Sometimes it's about who is making the decision. We call this acting without jurisdiction.
There was a case involving an immigration officer, right? Abdallah Ali.
Yes, this is a classic know your target case. A principal immigration officer tried to deport a man named Abdallah Ali. Now, under the law, the immigration officer has the power to deport non-citizens who are in the country illegally.
That's their job.
But it turned out that Abdallah Ali was a citizen of the country.
Oops.
Big oops. The moment it was established that he was a citizen, the officer's power just evaporated. He had no jurisdiction over him.
None.
The court said the decision to deport him was illegal because the officer was acting outside the scope of his authority. You can't use non-citizen powers on a citizen.
It sounds so simple, but these mistakes happen constantly.
They do. And then you have improper delegation. This is a big one in bureaucracies where everyone wants to pass the buck. There's a Latin maxim, delegatus non potest delegar.
A delegate cannot further delegate. I've been practicing.
Excellent pronunciation, yes. It means if Parliament gives a specific power to you, the minister, you can't just hand it off to a junior clerk and say, you handle this, I'm going to lunch.
There's a case about burning cotton plants that illustrates this perfectly. Rahomutula Gulamani VR. It sounds like something from a history book.
It is, but the principle is timeless. The law gave the governor the power to make rules about when cotton plants had to be uprooted and burnt. This was to prevent diseases in the crops. Serious stuff. So the governor has to set the date. Burn your plants by March 1st.
Okay.
Right. But the governor didn't make the rule. He delegated the power to the director of agriculture. And the director set the date.
Seems efficient. The director probably knows more about agriculture anyway.
Maybe so. But the law didn't give the power to the director, it gave it to the governor. A farmer was prosecuted for not burning his plants by the director's date. He challenged it.
And the court let him off.
The court said the director's order was void. The governor had no power to pass that responsibility to someone else. It was improper delegation.
I love that. It really shows that details matter. You can't just assume that because someone is the government, they can do whatever they want. They have to check their receipt. Did Parliament give me this power or you?
That is the essence of ground one. Illegality. Stick to the letter of the law.
Okay, let's move to ground two. This is my favorite one because of the name. Irrationality. But in the legal texts, they call it Wendesbury unreasonableness. Why do lawyers have to make everything so complicated?
It's tradition. It's named after the case-associated Provincial Picture Houses v. Wensbury Corporation from 1948. It was a dispute about whether cinemas could open on Sundays.
Gripping stuff.
But the standard it set is legendary. So, let me ask you, if you think a government decision is unreasonable, what do you mean by that?
I usually mean it's stupid. Or I disagree with it. Like, if they raise taxes, I think that's unreasonable.
And that is exactly why you would lose your case. In judicial review, unreasonable doesn't mean stupid. It doesn't mean wrong.
What does it mean?
The threshold is stratospheric. Lord Green, in that case, defined it as a decision that is so outrageous in its defiance of logic or accepted moral standards that no sensible person who had applied his mind to the question could have arrived at it.
No sensible person. So it's basically saying the decision maker must have taken leave of their senses.
Effectively, yes. It has to be absurd. If a decision is within the range of reasonable responses, even if the judge thinks it's the worst of the reasonable responses, the court won't interfere.
So if there are 5 ways to solve a problem, and the minister picks the worst one, but it's still a solution, the court stays out of it.
Exactly, because that's policy. But if the minister picks a solution that makes 0 sense, That's Wensbury.
Can we see this in action? I want to contrast a rational but unpopular decision with an irrational one.
Let's look at Paul Kika v. Attorney General. In
Okay.
this case, there was a public official, Paul Kika. There was a restructuring, and he ended up holding a title but not actually doing the substantive work of the office.
The dream. Getting paid to do nothing.
Well, the Inspector General of Government, the IGG, didn't think so. The IGG decided he shouldn't be earning a full salary if he wasn't substantially employed in the role. They cut his pay.
And Kihika sued.
He argued it was irrational. He had the title. He should get the money.
Right.
But the court looked at it and said, no, the IGG's decision makes sense. You can't be paid for work you aren't doing. There is a logic to it. It might be harsh for Kihika, but it's not outrageous. So the decision stood.
Okay, so that passed the test. What failed the test? What does a truly irrational decision look like?
For that, look at Dot Services Ltd v. Attorney General.
Dot Services is a big construction firm.
Right. A commission of inquiry had recommended that Dot Services be punished and blacklisted from government contracts. They alleged bribery and bad behavior.
Sounds serious.
It is serious, if it's true. But when the court looked at the commission's report, they asked, where is the evidence? There wasn't any. No hard evidence of bribery, no proof of connivance, just suspicion, just vibes, basically.
They tried to destroy a company's business based on a hunch.
Exactly. And the court said that basing a punishment on mere speculation without evidence is irrational. It defies logic to punish someone when you have no proof they did anything wrong. That is arbitrary power.
That makes sense. It would be like a referee giving a red card because he thought a player might kick someone later.
Perfect analogy. That is Wensbury unreasonableness. And closely linked to this is the idea of relevant versus irrelevant considerations.
Right.
To act rationally, you have to look at the factors the law tells you to look at and ignore the ones it doesn't.
There's a case involving a rugby club that I found fascinating. Wheeler v. Leicester City Council. This brings in politics.
Ah, yes. This was the 1980s, the apartheid era in South Africa. The Leicester City Council was very left-wing, very anti-apartheid, rightly so, morally speaking.
We can all agree apartheid was bad.
Absolutely. Now, there was a local rugby club in Leicester. Some of the club's members decided to go on a tour to play in South Africa.
Which was seen as supporting the regime.
Exactly. The council was furious. They wanted to punish the club. So the council banned the rugby club from using the city's recreational fields for their practices and matches.
And their justification.
They said it was to harmonize race relations.
Okay, so they used their power over the fields to make a political point.
And that was the issue. The court looked at the law that gave the council power over the fields. The purpose of that law was to manage open spaces and recreation for the public. It was not to conduct foreign policy or punish people for their political views.
So even though the council had a good moral reason, they used an irrelevant consideration legally.
Exactly. They used a statutory power for an improper purpose. The court said this was irrational. You can't ban a rugby club from a field because you disagree with where they went on vacation.
That is a really tricky line, isn't it? Because in the court of public opinion, the council was the hero.
Right.
But in the court of law, they were the villain.
That is why judicial review is so hard. It forces you to separate your morals from the mechanism. The referee doesn't care if the team is fighting against evil. If they handball it, it's a handball.
Okay, let's move to the third ground. We've done illegality, the box. We've done irrationality, the insanity test. Now we have procedural impropriety.
This is often the most relatable ground. It's also known as the breach of natural justice.
Natural justice. It sounds almost biblical.
It's the closest thing law has to religion. It's about fair play. There are two pillars here, two Latin phrases that act as the bedrock of fairness. First, audi alterum partem.
Hear the other side.
Yes. The right to be heard. You cannot be condemned unheard.
This seems so basic. Like, if my kid hits his brother, I ask him, why did you do that? Before I send him to timeout.
You'd be surprised.
But governments forget this all the time.
Constantly. Arrogance is a powerful drug. The classic case that cemented this is Ridge v. Baldwin. This is the Magna Carta of natural justice in the UK.
Set the scene for us.
It's 1964. Charles Ridge is the chief constable of Brighton, the top cop. He had been accused of conspiracy to obstruct justice. Serious charges. But he went to criminal court and was acquitted. He was found not guilty.
Okay, so he's cleared. Back to work.
He thought so. But his bosses, the watch committee, decided they didn't want him back. They met in secret. They didn't tell Ridge they were meeting. They didn't tell him they were considering firing him. They just voted and sacked him.
No phone call, no come in and explain yourself.
Nothing. Ridge sued. He said, "You can't just fire me without a hearing." The lower courts actually sided with the committee, saying they are the bosses, it's an administrative decision.
But the House of Lords.
The House of Lords went ballistic. Lord Reed gave a judgment that changed history. He said you cannot take away a man's office or his reputation without telling him what he's accused of and giving him a chance to defend himself. They declared the decision null and void.
Null and void. That's a powerful phrase. It means legally the firing never happened.
Exactly. It reinstated him, technically, so he could get his pension. This case freed natural justice. It established that this right applies almost everywhere: universities, trade unions, licensing boards.
We see this in universities a lot. There was the Ugandan case of Bwao Ivan v. Maker University.
A very relevant case for students. Bwao Ivan was the guild president. There was a strike. The university administration, in a panic, suspended him and other students.
Did they give them a hearing?
No. They just kicked them out. No proper notice, no chance to bring a lawyer, no chance to see the evidence. The High Court relied on Ridge v. Baldwin and said, "You can't do that. The suspension is void."
So, if I'm a student facing expulsion or an employee facing the sack, what does a fair hearing actually look like? It's not just sitting in a room, is it?
No, it has to be meaningful. The courts have broken it down into 3 elements. First, notice. You must know what you are accused of and when to appear.
You can't defend yourself against a surprise attack.
Exactly. Second, disclosure. You must see the evidence against you. This is huge.
There's a case, Kanda v. Government of Malaysia.
Yes. Inspector Kanda was facing disciplinary action. The adjudicator, the guy judging him, had a report on Kanda's conduct. But Kanda never saw the report.
So the judge is reading a secret file, and the accused doesn't even know it exists.
Exactly. How can you argue against a lie if you don't know the lie is being told? The Privy Council said that is fundamentally unfair. If the judge sees it, you must see it.
And the third element?
Opportunity to rebut. You must be able to correct or contradict prejudicial statements. You have to be allowed to speak.
Okay, so that's the first pillar, right to be heard. The second pillar of natural justice is nemo judex in causa sua.
No one should be a judge in their own cause. The rule against bias.
Basically, you can't be the referee if you're betting on the game.
Or if your brother is playing, or if you have a grudge against the goalkeeper. Bias comes in 2 flavors. First, pecuniary interest money.
The classic case here is Dimes v. Grand Junction Canal. This is a wild story.
It is. It involves the Lord Chancellor, Lord Cottenham. He was the highest judge in England. He presided over a massive case involving a canal company. He ruled in favor of the company.
Seemed normal.
Until someone did some digging. It turned out Lord Cottenham owned a significant number of shares in that very canal company. Huge, oops. Now here's the thing. Nobody thought he was actually corrupt. He was a very rich man. These shares were a tiny part of his portfolio. He probably didn't even think about it.
But still.
But the House of Lords set aside his decision.
Why? If he wasn't corrupt.
Because of the principle. They established the rule of strict liability for financial interest. If you have a financial stake in the outcome, however small, you are disqualified, period. It doesn't matter if you are unbiased in your heart, you are out.
Because it looks bad.
Exactly. Justice must not only be done, it must be seen to be done. If the public sees a judge ruling for a company he owns, they lose faith in the system.
Which brings us to the second flavor, non-pecuniary interest. Personal bias, favoritism, relationships. This is harder to prove though, right?
Much harder. You can't just check a bank statement. The test here comes from Metropolitan Properties v. Lannon. The question is, would a fair-minded and informed observer conclude there was a real possibility of bias?
So it's the reasonable person test again. We're asking the person on the street.
Yes. For example, in remedicaments, a member of a tribunal applied for a job with a consultancy firm. That firm happened to be an expert witness in the case she was hearing.
While she was hearing the case.
Yes. She realized the conflict later and withdrew the application, but the damage was done. The court said a fair-minded observer would think, wait, she wants a job from these guys? Can she really be impartial towards their evidence?
And that real possibility is enough to kill the decision.
It is. And when we say kill, we mean it. A decision made in breach of natural justice is void ab initio.
From the beginning.
Right. It's not just a bad decision. Legally, it's a nullity. It's like it never existed.
Okay, so we've covered the grounds. Illegality, irrationality, procedural impropriety. Let's say I'm the applicant. I've gone to the high court. I've proved the government messed up. I've proved the PPA sanctioned an illegality. What do I get? What are the remedies?
We call these prerogative orders. Think of it as the court's toolkit. There are 3 main tools the judge can reach for.
Tool number 1, the eraser.
That would be certiorari, or a quashing order. The court calls up the record of the decision and quashes it. It wipes it off the books. This is what happened in Clear Channel. The court quashed the decision to let the tender process continue.
It looks backward.
It looks backward and undoes what was done.
Okay. Tool number 2, the shield.
Prohibition. This is a stopping order. It prevents a body from acting unlawfully in the future. Imagine a disciplinary tribunal is about to hear a case against you, but you know they don't have jurisdiction.
Right.
You don't want to wait for them to fire you and then sue. You want to stop them now. You ask for prohibition.
And tool number 3, the whip.
Mandamus. This is a compelling order. It forces a public officer to do their job.
Because sometimes the abuse of power isn't doing something wrong, it's doing nothing at all.
Exactly. Laziness or political cowardice. In Padfield v. Minister of Agriculture, the minister refused to consider a complaint from milk producers because he thought it would be politically embarrassing. He just sat on it.
He ghosted them.
He did. The court issued an order of mandamus saying, "You have a duty to consider this. Do your job." They didn't tell him what to decide, but they told him he had to decide.
Now here is the catch, and this is terrifying. You can prove your case. You can prove the minister was irrational, but the judge can still say no.
That is the sting in the tail. These remedies are discretionary. They are not automatic rights like in a contract case. If the court thinks you waited too long, or if you have unclean hands, meaning you acted badly yourself, or if quashing the decision would cause administrative chaos, they can refuse to grant the order.
So you have to be on your best behavior if you want the referee to help you.
Absolutely. You can't be a villain and ask for a hero's remedy.
Now, speaking of behavior, let's talk about the obstacle course you have to run just to get into court. Judicial review isn't a free-for-all. You mentioned earlier that not just anyone can sue.
The courts call this gatekeeping. They don't want every disgruntled person clogging up the system. The first hurdle is locus standi, or standing.
Who are you to complain?
Exactly. You need sufficient interest. You can't just be a busybody. If your neighbor is denied a license, you can't sue. Your neighbor has to sue.
Although, I've heard this is changing.
In Uganda, yes. Under Article 50 of the Constitution, the rules are widening to allow public interest litigation. If it's a human rights issue or an environmental issue, a concerned citizen can sometimes sue on behalf of others. But generally, you need skin in the game.
Then there's the clock. Time limits.
This is brutal. In ordinary civil cases, you might have years to sue. In judicial review, you usually have 3 months.
3 months. That's incredibly fast. By the time you find a lawyer and get your paperwork together, time is almost up.
It is. We saw this in Muwanguzi Mugalu v. Uganda Railways. The court emphasized that strict timeline. The rationale is that public administration needs certainty. You can't have a school board decision or a road tender from 5 years ago suddenly overturned.
Right.
It would unravel everything that happened since.
So if you sleep on your rights, you lose them. And then there's this weird rule about giving notice. The 45-day statutory notice.
This is a contentious one in Ugandan law. The Civil Procedure and Limitation Act says you must give the government 45 days notice before you sue them. The idea is to give the Attorney General time to investigate and maybe settle before going to court.
But wait, if I'm about to be deported tomorrow, or if a forest is about to be cut down today, I can't wait 45 days.
That is the conflict. In Greenwatch v. Attorney General, the court ruled that requiring 45 days notice for human rights violations is absurd. Rights need immediate protection. If you wait 45 days, the damage is done. The Constitution trumps the act.
But in other cases, like Cabandi's v. KCCA, courts have upheld it.
Yes, there is a tension there. Judges are split. But the general trend is that technicalities shouldn't defeat justice, especially in urgent matters.
One last hurdle. Exhaustion of local remedies.
This is the don't jump the queue rule. If there is a specific tribunal set up for your problem, like the Tax Appeals Tribunal for tax disputes, you have to go there first.
You can't run straight to the High Court.
No. Judicial review is a remedy of last resort.
In Dr. Wenceslaus Ramamakuza v. CAA, the applicant tried to use judicial review for what was basically an employment contract dispute.
And the court struck it out. They said, go to the industrial court, use the proper channels, don't bother the high court until you've tried everything else.
Okay, we're almost at the end of our dive.
Yeah.
But we have to talk about the Joker card. The get-out-of-jail-free card for the government, national security.
The ultimate trump card. We teased this with the GCHQ case earlier. Now let's tell the story.
Margaret Thatcher versus the spies.
Effectively, yes. In the 1980s, the UK government decided that trade unions at GCHQ, the intelligence headquarters, were a risk. They thought strikes could interrupt vital intelligence gathering. So, overnight, Thatcher banned unions at GCHQ.
Now, normally, based on natural justice and legitimate expectation, the union should have been consulted. You can't just change the terms of employment like that.
Correct. And the unions sued. They argued procedural impropriety. And the House of Lords actually agreed. They said, yes, normally this would be unfair. You should have consulted them. But the government produced evidence that the ban was for national security, and the moment those words were spoken, the court bowed out.
So national security trumps natural justice.
In almost every case, yes. The courts take the view that they are judges, not generals. They are not equipped to judge what is or isn't a security threat. That is for the executive. So if the government plays the national security card and backs it up with evidence, the judicial review stops there.
That is a sobering thought. It means there is a limit to the referee's power.
There is. The referee controls the game, but the government owns the stadium.
So let's wrap this up. We've been through the weeds. We've seen the boxes, the insane decisions, the secret hearings. What does this all mean for us, the listeners?
It means that we live in a system of checks and balances. Judicial review is the high court asking, did you follow the rules? It ensures that no one, not the minister, not the CEO of the aviation authority, not the university vice chancellor, is above the law.
It transforms authority into accountability.
Beautifully put.
So here is a final thought for you to chew on. We talked about irrationality decisions that are so wrong, they are crazy. But where is the line? If the courts stretch irrationality too far, do they just become the decision makers? If a judge says that policy is irrational, aren't they just substituting their opinion for the politicians?
That is the danger. We call it judicial activism. Where does the judge stop and the politician begin? It's a boundary that is constantly being tested.
Next time you see a government decision that makes you shake your head, ask yourself, is it just wrong? Or is it Winsbury unreasonable? And if it is, who is going to blow the whistle?
Stay curious.
Thanks for diving deep with us. We'll catch you on the next one.